and welcome everyone. My name is Amanda Stedman and I'm the Principal Knowledge Lawyer here at BDBF, and I'm joined today by my colleague Tom McLaughlin, a Managing Associate in our team. We're going to cover the topic set out on the slide, looking at some very recent changes that came into force last month, and then looking ahead to consider the many different developments that lie ahead this year. We're going to speak for about 50 to 55 minutes, and after that, there'll be some optional time for questions and answers. We're presenting in webinar format today, so the best way to ask your questions is to type them into the Q&A box, which you'll find at the bottom of your screen, and you can ask questions anonymously if you prefer. Finally, today's session is being recorded, although the Q&A segment won't be. After the session, we will circulate the recording together with a copy of the slides that we are using today. We will also send you a pack of materials which will give you more information on all of the developments that we're going to talk about, should you wish to deepen your knowledge on any of these areas. So turning first then to some changes made to the Equality Act on the 1st of January. And you would be forgiven if these changes were not on your radar. There was no big fanfare about them from the government, and the reason for that is because these changes do not form part of the Conservative government's employment law policy agenda. So I've set them out on the slide, and I'm afraid I've offended all the rules on PowerPoint today. The reason for that is I'm not going to talk about all of the changes on this slide. I'm just going to talk about the first two. But I thought it would be helpful for you to have something to refer back to at a later date. So, as I said, these changes are not so much part of the government's employment law policy agenda. Rather, they're best described as a codification of existing EU discrimination law principles, originating mainly from decisions of the European Court of Justice. Now, these principles had applied in the UK when we belonged to the EU and for a period of time thereafter, but they were effectively erased from UK law at the end of 2023. So the long and short of it is that the loss of those principles left the UK's discrimination law framework at odds with that of the EU. So to avoid that, the government decided to write these principles into the Equality Act with effect from the 1st of January 2024. So it's really the form of the law that has changed rather than the substance. But having these principles actually written down in the Equality Act means there are no grey areas about whether these principles apply. There is clarity about what is expected from you as employers. So let me just touch on these first two items then. The first one concerns discrimination in recruitment. The old position under the Equality Act was that in order for discrimination to occur in a recruitment process, there needed to be an active recruitment process underway with an identifiable victim. But an ECJ decision from a couple of years ago said that the protection should be wider than this. In the case in question, a lawyer on an Italian radio show said he would never hire a gay person to work in his law firm. Even though there was no active recruitment exercise underway and no identifiable victim, the remarks were held to be capable of amounting to unlawful discrimination about which a claim could be brought. And a claim was indeed brought by a pressure group. So the Equality Act has been amended to reflect that position. And you may think that the chances of a comment being made on a radio show like this are pretty slim. And that may be true, but remember, of course, we live in a digital age where everyone has a video camera in their pocket and can broadcast to the world at large within seconds. The second row concerns changes to the field of pregnancy, childbirth and maternity, and there are several changes to tell you about here. So first of all, special treatment of women on maternity leave. So the old position was that employers were able to afford special treatment to women in connection with pregnancy and childbirth and be safe in the knowledge that this wouldn't amount to discrimination against men. However, ECJ law made it clear that the special treatment could also be extended to women on maternity leave. So the Equality Act has been amended to expressly provide that special treatment may be afforded to women in connection with maternity leave, as well as pregnancy and childbirth. So, for example, providing enhanced pay to women on maternity leave, but not to men on paternity leave or shared parental leave, would not be discriminatory. The second change concerns unfavourable treatment of women returning from maternity leave. So you may be familiar with the term the protected period, and this covers the duration of the pregnancy plus any statutory maternity leave. The old position was that pregnancy and maternity discrimination was unlawful if it took place during the protected period or after the protected period, if it stemmed from a decision taken during the protected period. But this left a gap in the protection because it didn't extend to unfavourable treatment, which occurred after the protected period, which was because of the pregnancy or pregnancy-related illness. So that has been amended to provide that women are also protected from unfavourable treatment once they come back from maternity leave, if that treatment is related to the pregnancy or a pregnancy-related illness. So, for example, if a woman had a lot of pregnancy-related sick leave, she returns from maternity leave, perhaps takes some more sick leave, and you commence the capability process on the grounds of her sickness absence, taking into account that pregnancy-related sickness, that could potentially be discriminatory. The third change concerns protection for women entitled to maternity leave under occupational schemes. The old position was that where a woman wasn't entitled to statutory maternity leave, so for example, an LLP member, she had entitlement to maternity leave under an occupational scheme. So again, an LLP member entitled to, say, 52 weeks maternity leave under the LLP members agreement. Her protected period during which she would be protected from pregnancy and maternity discrimination was limited to just 2 weeks. So very short compared to a woman entitled to statutory maternity leave who is protected for the whole of the 52-week maternity leave period. So this has been amended to provide that the protected period for women entitled to occupational but not statutory maternity leave is now for the whole of that occupational maternity leave period, up to 52 weeks. So in other words, they're put into the same position as someone entitled to statutory maternity leave. And the final change to alert you to concerns breastfeeding mothers. So believe it or not, the old position was that breastfeeding women were not protected from less favourable treatment at work. This has been amended so that less favourable treatment at work because of breastfeeding may constitute direct sex discrimination. So a failure, for example, to conduct a risk assessment or a failure to allow breaks or a suitable clean and private space to express milk could give rise to a discrimination claim. I'm not going to talk about the remaining points on the slide, save to say that in each case, no fundamental change has been made to the law on indirect discrimination, equal pay, or disability discrimination. Rather, the changes that have been made have the effect of opening up such claims to a wider pool of people who would otherwise not have been able to bring a claim. So you could potentially see more disputes or claims arising in these areas. So, what do you need to do with all of this? Well, the good news is that the changes don't necessitate rewriting policies, save that you may wish to set out in your maternity policy the support that you offer to breastfeeding mothers if you don't already do that. Other than that, I think the key takeaway is to make sure that the right people in your business know about these changes. So your HR team should have an overview of the changes, and it would be a good idea when rolling out diversity training to line managers to underline the very wide scope of protection from discrimination that applies to new mothers. Make it clear that care should always be taken when making decisions which affect them. Moving on then to look at changes in the sphere of working time and holidays. So on the 1st of January, we saw a raft of changes to the working time regulations. This is also Brexit related insofar as some of the changes write EU law principles into the working time regs, which otherwise would have been lost at the end of last year, while other changes are only possible because we are now no longer members of the EU. So let's take a look at the changes. So first of all, on the 1st of January, we had 3 key changes to note. The first one concerns what counts as holiday pay. So you'll all be familiar with the fact that workers are entitled to 5.6 weeks annual leave per year, which is split into 2 buckets. First of all, you have what's known as Regulation 13 leave, which is the 4 weeks leave mandated by EU law. And then we have Regulation 13A leave, which is the additional 1.6 weeks granted by the UK government. Now, the ECJ made it clear that workers must be paid their, quotes, normal pay for Regulation 13 leave, and there are a host of decisions discussing what this should include. In contrast, workers are only entitled to be paid their basic pay for that additional 1.6 weeks leave. So on the 1st of January, the working time regs were amended to spell out which types of payments count for the purposes of Regulation 13 leave. And effectively, this mirrors the ECJ rulings on this issue. So the left-hand column on the slide before you sets out the payments that will count for these purposes. Strictly speaking, you should have already incorporated these types of payments into your calculation of Regulation 13 holiday pay, but if you haven't, now is the time to regularise the position. Remember that you may still pay basic pay only for the additional 1.6 weeks leave. However, the new government guidance recommends that if you wish to do that, then it should be explained clearly in the workers' contract or your staff handbook. The working time regs have also been amended to clarify that when workers may carry over accrued annual leave. And again, this change is designed to reflect the rulings of the ECJ on this issue into our domestic law for the first time. So I've set out on this slide here the full position. So it sets out the rules on carrying over leave, so the situations in which leave may need to be carried over, what can be carried over, and for how long it may be carried over. And I hope it's all fairly self-explanatory, so I'm not going to talk it through now. The slide hopefully gives you all you need, but do get in touch if you have any specific questions on this. There is one other thing to mention in respect of carryover. One other change concerns the special rules that permitted workers to carry over their Regulation 13 leave for up to 2 years, where they couldn't take it because of the COVID pandemic. From the 1st of January 2024, workers will no longer be able to do that, and anyone who has carried over COVID-related leave has until the end of March this year to use it up. And the final change to tell you about from the 1st of January is a small change related to your record-keeping requirements. So back in 2019, the ECJ had ruled that the Working Time Directive required employers to have a system in place to measure the daily working time of every worker. And importantly, they said that system had to go beyond merely just recording overtime hours or piecing together other sources of information to work out someone's daily working hours. The system had to be objective, reliable, and accessible. Now, the UK government didn't like this. They felt it placed too high a burden on employers. So on the 1st of January, the working time regs have been amended to clarify that businesses don't have to keep a separate record of daily working hours, provided they can demonstrate compliance with the law without doing so. Now, that's not all that's happened in the sphere of working time law, I'm afraid. There are some more significant changes which will apply to irregular hours workers and part-year workers from the 1st of April this year. So the first question I think we need to explain is what do these terms actually mean? So we have new definitions of both of these types of workers. An irregular hours worker is a worker whose number of paid working hours in each pay period in a leave year is wholly or mostly variable. So, for example, a hospitality worker who works a different number of hours each week. But it wouldn't include, for example, a worker who works a rotating 2-week shift pattern of 15 hours fixed in the first week and 20 hours fixed in the second week. And that's because their working hours are fixed and not variable. So that's a regular hours worker. What about part-year worker? Well, a part-year worker is a worker who has periods within a leave year of at least 1 week where they're not required to work and for which they are not paid. So that would include, for example, a seasonal worker in the farming industry who only works and gets paid during the spring and summer months. In contrast, it wouldn't include a term time only worker in the educational sector if their salary is paid in equal instalments throughout the year, including holiday periods when they are not working. So what changes are being made for these two types of workers? Well, the first change concerns how they accrue their annual leave, and the second change concerns how they are paid for their annual leave. So looking first at the accrual change. Under the new system, these workers will accrue annual leave as they go. They will accrue annual leave at the end of each pay period, calculated at a rate of 12.07% of the number of hours that they work in that pay period, up to a maximum of 28 days per year. And the aim of this change is to provide workers with a steady stream of holiday entitlement as they work. It's also hoped that this will simplify the calculation of holiday entitlement for you as employers. And finally, the new system also means that the annual leave entitlement of these kinds of workers will be proportionate to the number of hours that they actually work. Now, it all sounds a bit complicated, but I'm pleased to say that the new guidance that accompanies these changes sets out worked examples of how to calculate the leave entitlement under this new accrue as you go system. And it also explains what to do if, for example, the worker is off sick or goes on a period of family leave. So I would say that the guidance is essential reading for all of you who have workers that fall into these two categories. The other point to note here is that you'll need to decide whether to allow these kinds of workers to book and take holiday in excess of what they have actually accrued under this system. If you do allow them to take more than they have accrued, what you should do is ensure that you have a right to make deductions in respect of any holiday which is taken but not yet accrued at the point of termination. The other change for these workers concerns how you calculate and pay holiday pay, with a new system of rolled up holiday pay being introduced. So rolled up holiday pay is a system whereby no holiday pay is actually paid during the worker's holiday. Instead, pay is enhanced during periods of work. In other words, the enhanced payment represents a payment in lieu of holiday pay. Now, way back in 2006, the ECJ said that the practice of rolled up holiday pay was unlawful and that workers should get their holiday pay when they go on holiday. Now, as an EU member state, we had to abide by that ruling. Now we are not. We can do as we wish. So what's changing? So for leave years commencing on the 1st of April 2024, you are permitted to pay rolled up holiday pay to these types of workers, but note it will not be permitted for other types of workers. And if you do decide to introduce rolled up holiday pay, there are some important points to remember. So first of all, you need to check the worker's contract to see whether payment in this way would amount to a variation of that contract, for which you would probably need to get their agreement. The rolled up holiday pay itself has to be calculated at 12.07% of the worker's total pay in a pay period. And again, that guidance that I mentioned earlier gives some good worked examples of how you actually do that. The rolled up holiday payment must be clearly itemised on the worker's pay slip. And a really important point to note, that if the worker carries over any annual leave into a new holiday year, don't forget that you will have already paid them for it. So don't double pay them by accident. The other very, very important point is that you are not obliged to adopt a system of rolled up holiday pay if you don't want to. It is optional. You may prefer to pay holiday pay when holiday is taken, and where that is done, you will need to calculate their holiday pay over a reference period of 52 weeks. And again, the guidance that I mentioned gives you worked examples of how to do that in practice. So where does this all leave you? Well, on this slide, I've just rounded up the various action points that I think I've already mentioned. So I won't talk them through again, but I thought it might be useful for you to have them all in one place. I'm going to hand over now to Tom, who's going to talk to you about flexible working.
Thanks, Amanda. So turning to various changes in the world of flexible working, and starting with the fact that the right to request flexible working is going to be extended to all employees. So currently, an employee needs 26 weeks continuous service in order to make a flexible working request. However, new regulations will remove that service requirement on the 6th of April this year and make it a day one employment right. This obviously brings forward the point at which you will need to think about flexible working in relation to particular roles. And we think you'd be wise to state which, if any, flexible working options would be suitable for particular roles in job advertisements. You may also wish to identify candidates' preferences at the job interview stage. Now, this won't prevent an employee from asking for something different on day one of their employment, but an upfront discussion might allow suitable patterns to be identified from the off, rather than dealing with requests in the first few months of employment. But you must take care to hold those discussions in a non-discriminatory way, for example, by asking open questions about whether a candidate has a preferred working pattern and not making adverse comments about a preferred pattern or assuming that a particular candidate will want to work in a certain way. There's also going to be changes to the flexible working request procedure expected by the end of July this year. A new act will make the following reforms to the flexible working process. So employees will no longer have to explain what effect they think the requested change will have on their employer and how the effect might be dealt with. Employees will be permitted to make 2 flexible working requests per year rather than 1. Employers will be required to consult with employees before refusing requests, and employers will have 2 months to make a decision on a flexible working request rather than 3 months as currently. So all changes to make flexible working requests a bit easier for employees and a bit harder for employers. It's not exactly clear when the changes will come into force. The government said it expects the measures to come into force approximately 1 year after the act enabling them came into force, to give employers some time to prepare. So that means sometime in July this year. We think it remains possible that actually these changes will be introduced on the 6th of April in order to accompany the change to make flexible working a day one employment right. There's going to be a new statutory ACAS code on flexible working. The draft was laid before Parliament in December last year, and it's likely to come into force in April this year. And although the code is not legally binding as such, it will be taken into account by employment tribunals when considering relevant cases. And so it's going to count against you if the code has not been followed. The code has been updated to reflect changes to the way we all work since it was introduced in 2014 and to reflect the reforms I've just discussed. Some points from the code: it recommends that employers have a clear policy for handling flexible working requests. It clarifies that while employees may make up to 2 requests in a 12-month period, they can only have 1 live request at any one time. It reminds employers that they must consider requests in a reasonable manner and must agree to a request unless there is a genuine business reason not to do so, and the fixed list of reasons for rejecting a request that you're familiar with are unchanged. The code recommends that where an employer accepts a request, it should confirm the decision in writing and offer the employee a chance for a discussion to clarify any information which may be helpful in implementing the agreed arrangements, and that you should keep records of those sorts of discussions. And it also underlines that employers must not reject a request without first consulting with the employee. And the code provides a good amount of detail, which I'd encourage you to look at, which clarifies what a consultation process should involve. I'm going to talk now about a brand new statutory right for workers to request more predictable working patterns. The act needed to bring about this change was passed in September last year, but we're still waiting for regulations which will set out some of the finer detail. We're also waiting for a new statutory ACAS code of practice governing how you should handle these requests, although there has been a draft subject to consultation, and it's expected to come into force by the 18th of September this year, because that's 1 year since the act was passed. So we're light on some of the detail, but what do we know so far? The right is open to workers as well as employees, compared to flexible working requests, which are only open to employees. It's expected that workers will need to have worked for a minimum amount in the 6 months before the request is made to be eligible. Where eligible, workers will be able to request a more predictable working pattern where their current work pattern lacks certainty in terms of hours, days, or time works. And work pattern also covers the length of the contract, and there'll be a presumption that a fixed-term contract under 12 months lacks predictability. And the purpose of the request must be to achieve a more predictable working pattern. In terms of how requests should be made, they'll need to be made in writing, state that it is a request for a more predictable working pattern, and set out the proposed change and the date on which the worker wants it to take effect. They can make up to 2 applications in a 12-month period, but they can't be concurrent. And it's worth noting this time limit includes any similar requests made under the separate flexible working regime. As employers, you'll be required to consider these requests in a reasonable manner, although that is not defined in the Act, and to notify the worker of the decision within 1 month, so quicker than for flexible working. And it's likely that employers will be expected to meet with the worker to discuss the request and to allow them to be accompanied, although that won't be a statutory right, the right to be accompanied. You don't have to accept requests, but you will be expected to consider alternative options and discuss those with the worker. And then there's going to be a fixed list of reasons for which requests can be rejected. You won't be obliged to offer a right of appeal, but you may choose to do so. So what happens if something goes wrong? The worker, if the employer fails to follow the procedure or rejects a request based on incorrect facts, the worker will have 3 months to bring a claim in the employment tribunal. The tribunal can order the employer to reconsider the application or pay compensation to the worker. The maximum amount of compensation will be in the regulations that we're waiting for. We expect it will mirror the maximum amount under flexible working, so 8 weeks pay. And then workers will be protected from detriment or dismissal for having requested a predictable working pattern or bringing proceedings to enforce that right. So what do you need to do to prepare? We've set those out on this slide. We think, as I say, that you should consider whether to address flexible working in job adverts and interviews. You will certainly need to revise your policy to reflect these reforms. And although employees are no longer required to explain the potential effect of their request, we'd recommend that this is still encouraged through your policy. And your policy will also need to capture the new right to request predictable working. You'll need to have a think about what your consultation process looks like and whether it comes up to scratch with the ACAS code. There'll almost certainly need to be training for line managers on how these reforms will impact how they should handle flexible working requests. You might need to think about what additional resource you need, given that there's a new type of request that can be made and requests can be made more frequently. And also think about your record keeping procedures. And again, to keep track of how many requests people are making in a 12-month period. I'm going to move on now to talk about redundancies and their relationship with pregnancy and family leave and some changes coming in this regard. Currently, employees absent on either maternity, adoption, or shared parental leave get special protection in a redundancy situation. The law provides that before making a woman who's on maternity leave or an employee on those other types of leave redundant, an employer must offer a suitable alternative vacancy to them where one is available. So in other words, the employee moves to the front of the queue for such a role ahead of other colleagues, and they've got a right of first refusal. And if you don't do that, the employee can bring an automatic unfair dismissal claim. So in 2019, the government consulted on extending that right, and to this end, backed a private member's bill which aimed to deliver those changes. What will happen is the existing protection will be extended to pregnant employees and to those who've recently returned from maternity, adoption, or shared parental leave. The Act enabling that came into force on the 24th of July last year, and it allows for regulations to be made with the new detail. and they were laid before Parliament in December last year, and if passed in their current form, means the changes will come into force on the 6th of April. So pregnant employees who are at risk of redundancy will have that priority, and this will be known as the protected period of pregnancy. And it will start from the day on which the employee informs her employer of her pregnancy, where that notification is made on or after the 6th of April. In practice, many women notify their employers around 12 weeks pregnant, but it should be remembered that if a woman notifies her employer sooner, then the protection will start sooner. The regulations don't stipulate how the notification has to be made, so you should work on the assumption that a conversation with a manager could be enough to count as notification. And that protected period ends on the day that statutory maternity leave starts. There are some separate rules around dealing with miscarriage and stillbirth as well. And employees who return to work from a period of maternity leave that ends on or after the 6th of April and who are at risk of redundancy will have that priority for an additional protected period. And that period starts from the day they return from statutory maternity leave, which might not actually be the first day back in the office, because often people tag on a period of holiday. And it ends 18 months after the child's birth, if the employer was notified when that was, or if they're not given that notification, from 18 months after the first day of the expected week of childbirth. So in practice, this means the additional period will differ depending on when the woman starts a maternity leave in relation to the date of the child's birth. We've got some worked examples on this slide. So at the top, Jane notifies her employer when she's 3 months pregnant. She's in a relatively high risk situation, so she starts maternity leave quite early, 2 months before baby's due. The child is born in the expected week of childbirth. Jane notifies her employer. She takes the full 12 months maternity leave entitlement and returns to work 10 months after the child's born. So she'll have an additional protected period of 8 months, which is 18 months after the birth. In Sarah's case, the additional period is different because she notifies her employer at 3 months pregnant. She works right up to the expected week of childbirth. The child's born in that week. She takes 12 months maternity leave, and then she'll have an additional protected period of 6 months, because again, it's 18 months after the child is born. If she had tagged on some holiday or another type of leave, then that 6-month additional period would start running during that additional type of leave. And finally, in Huda's case, she again notifies her employer at 3 months pregnant. She starts maternity leave in the expected week of childbirth when the child is in fact born, but she only takes 3 months maternity leave. She will have an additional protected period of 15 months because, again, it runs from when the child is born. So it appears anomalous, but over the overall period still comes out around 24 months. But it's important when implementing this that HR managers are not thinking, it's another 6 months after the end of maternity leave. It's 18 months from when the child is born. There's going to be comparable rules for adoption and shared parental leave, which we'll cover in much more detail, along with some worked examples in the materials that we're going to circulate after the webinar. So for preparation, again, there will be updates to staff-facing policies and procedures in relation to redundancy. We'll need to think about who's going to deliver training to HR and managers where they're dealing with a redundancy process. And these changes, might affect imminent redundancy plans this year. If you're thinking about redundancies in Q1 or Q2, you're going to be in the realms of having to consider this extended protection. And you'll need to think about how you deal with a situation where there are alternative roles suitable for multiple protected employees, because that number will increase because the period of protection is increasing. Protected employees will have the right to claim automatic unfair dismissal where the employer fails to comply with these obligations. It's a day one employment right, so there's no requirement for 2 years service like in an ordinary unfair dismissal claim, and there's also a risk of discrimination claims if this has got wrong. So it's important to get on top of this as soon as possible. I'm going to hand you back to Amanda now.
Thanks, Tom. So I'm going to talk to you about the new right to carers leave, which is also coming into force on the 6th of April. So currently, employees with caring responsibilities have no specific rights to take leave in order to discharge their caring duties. They may be eligible to take other relevant forms of leave, such as unpaid time off for dependent emergencies or unpaid parental leave, or they might be able to make a temporary or permanent flexible working request. However, the charity Carers UK has reported that the pressures faced by carers have actually led to 1 in 10 to consider reducing their working hours or even giving up work altogether, with apparently 200,000 people leaving the workplace each year due to the caring pressures. So to help address this issue, in September 2021, the government confirmed that a day one employment right to carers leave would be introduced. The Carers Leave Act passed last May. That provided the pathway to the new rights and protections for employees. We were waiting for the regulations to set out the detail. We now have those. They were set out before Parliament in December, and if they're passed in their current form, will introduce the new carers leave regime on the 6th of April. So let's have a look at the right and who qualifies. So the right is that employees will have a day one right to take 1 week's unpaid carers leave in any 12-month rolling period to provide or arrange care for a dependent with a long-term care need. Now, note here that neither the Act nor the regulations define what counts as, quotes, providing or arranging care. And so that is something that is left open to interpretation. The right is to take 1 week's leave. That is prorated if you're on a part-time working arrangement. In this context, dependent means, as set out on the slide, I won't read through it, that dependent must also have a, quotes, long-term care need. And that extends further than the concept of disability that we're used to under the Equality Act, although that is included. But it also captures illnesses or injuries that require or are likely to require at least 3 months of care. So they may be illnesses or injuries that wouldn't meet the threshold for disability in the Equality Act. It also extends to the provision of care in relation to old age, although again, note that old age is not defined. Now, if you already provide a contractual right to carers leave, as some employers do, it's worth noting that an employee is not entitled to exercise the new statutory right and the contractual right separately, but they are entitled to take advantage of whichever right is more favourable to them in any particular respect. So that's the outline of the right. How will it work in practice? Well, employees may take carers leave in discontinuous blocks of at least half a working day, and that leave can be taken at different times and it needn't be taken consecutively. Alternatively, if they prefer, they can just take the whole amount of leave in one continuous block. So a couple of examples. Let's say Akash's wife was in a bad car accident. She has sustained damage to her legs and needs specialist physiotherapy once a week for 3 months, and she needs assistance to get to and from those appointments. Assuming Akash is a full-time worker, he could ask to take half a day's leave on up to 10 separate occasions, or a full day's leave on up to 5 separate occasions in order to assist his wife. Compare that with Jessica. Jessica's elderly father needs to move into a care home. Jessica could ask to take a whole week off for the purpose of visiting different care homes to identify a suitable home for her father and then deal with all the admin and practical issues associated with that move. There are notification requirements set out in the regulations. So employees have to tell you of their intention to take carers leave, and they have to specify that they are entitled to take carers leave. An important point to note here is that you are not able to require employees to supply evidence of their entitlement to take the leave. You have to just rely on their self-certification in this respect. When the employee tells you they want to take leave, they need to tell you which day or days they want to take the leave on, and that could cover the whole of their leave entitlement or just part of it. and they need to give you a certain amount of notice. I'm not going to talk you through the specifics on that, but there are rules on how much notice they need to give. The notice doesn't have to be in writing, but of course, there's nothing to stop you from asking in your own policies that employees do give notices in writing. I think that would be a sensible thing to do just to make sure that requests don't get lost. Can you postpone a period of leave if it doesn't work for you? Well, you can, where you reasonably consider that the operation of your business would be, quotes, unduly disrupted if the employee took the leave on the dates they've asked to take it. So it's not merely that it's just going to be a bit annoying or inconvenient. You've got to show that there would be undue disruption. If you can do that, then you can postpone the leave, but you must permit the employee to take the carer's leave at another time within a month of the first day of their request. And you'll need to consult with them about what the suitable alternative date will be. Employees taking carer's leave have certain protections, so they are protected during their leave. They will continue to be entitled to their existing terms and conditions, save as to pay. And after their leave, they have the right to come back to their original job, the one they were employed in immediately before the absence. And they also have rights to complain to an employment tribunal if they are subjected to a detriment or dismissed because they took or sought to take their carer's leave. So what do you need to do? Well, with just under 3 months to go until these new rights come into force, you should be finalising your approach to carer's leave now. So I think you need to consider the following issues. So who's going to own this within your business and make sure that you're complying with all the rules. And that will include things like preparing a new carer's leave policy, rolling out training to line managers, and obviously making sure you have good record keeping arrangements in place. You'll also need to think how you raise awareness of the new right amongst your staff. And then there are some other policy issues that you should be thinking about. So will you enhance the amount of leave that's available? And if so, to how much? Will you offer paid leave? And again, if so, how much? Will you extend the rights to non-employees on a voluntary basis? Will you relax the notice requirements that are set out in the regulations? And if so, what sort of notice would you require? So there are some policy considerations for you as well. Another change coming into force on the 6th of April are some reforms to the paternity leave regime. So back in June 2023, the government announced plans to make it easier for fathers and partners to take paternity leave. Then it all went a bit quiet, and I think we perhaps thought it wasn't really going to happen, but somewhat surprisingly, last month, the paternity leave amendment regulations were laid before Parliament. They are due to come into force next month on the 8th of March and will have effect in relation to children whose expected week of childbirth begins after the 6th of April or whose adoption placement is on or after the 6th of April. So what's going to change? Well, the changes are relatively minor, but they will necessitate some changes to your policies. So first of all, how statutory paternity leave may be taken is going to change. So at the moment, you'll be familiar with the fact that paternity leave either has to be taken as a single block of 1 whole week or 2 consecutive whole weeks. If only 1 week is taken, there's no second bite of the cherry. The employee can't come back and take the second week at a later date. So that's going to change. So employees can either take it as the current position, or if they want to, they can separate out the 2 weeks and take it as 2 separate blocks. But it does remain the case that leave can't be taken as blocks of days here and there. It does need to be taken as a whole week. Perhaps a bigger change is when the leave may be taken. So currently, employees have to take it within a relatively short window. They have 56 days from the birth or the adoption placement within which to take it. That's going to be extended to 52 weeks of the birth or placement for adoption. But do remember that it will remain the case that paternity leave cannot be taken where the employee has already taken a period of shared parental leave. So, for example, if an employee says they wish to split up their paternity leave into 2 separate weeks, perhaps taking 1 week at the beginning, 1 week towards the end of the year since the child's birth. They just need to be careful not to fall foul of that rule and lose their paternity leave if they've already taken shared parental leave. And finally, there are some changes around the notices that need to be given to you. So currently, employees wishing to take paternity leave have to basically tell you everything up front. So they need to tell you about the expected week of childbirth or the adoption placement. They need to tell you whether they wish to take 1 or 2 weeks, when they wish to take it, and they need to prove their entitlement to you. And all of that has to be given to you within no later than the 15th week before the expected week of childbirth, shorter window for adoption cases. That's all going to change. So from the 6th of April, the notice of entitlement to take leave and then the notice around when they want to take the leave are going to be separated out. So it's still going to be the case that not later than before the 15th week of childbirth, they'll have to tell you that they are entitled to take the leave and when the expected week of childbirth or adoption placement is. But in terms of telling you when they want to take the leave, they only have to give you 4 weeks notice of that. And again, a shorter window for adoption cases. So where does that leave you? What do you need to do? Well, not too much to do, but only 3 months to go. So a couple of things just to put onto your radar. So first of all, you'll need to update your paternity leave policy just to reflect these changes. So the shorter deadlines for giving notice, etc. You will also probably need to change the HR forms that you use to support the paternity leave process. I'm imagining that most of you use one form that covers entitlement and the proposed period of leave. That will need to be separated out into 2 separate forms. And finally, you probably just need to make sure that your managers understand that eligible employees are entitled now to take blocks of discontinuous leave within that first year of birth or adoption. In practice, I suspect that the majority of fathers will still tend to take the 2 weeks paternity leave as a single block, sort of fairly soon after the birth or adoption. I suspect we're unlikely to see dramatic changes in this area. I'm going to hand now back to Tom, who's going to talk to you about TUPE.
So some helpful changes to TUPE for employers. You may know the Transfer of Undertakings Protection of Employment regulations, referred to as TUPE, protect employees where there is a business transfer or in an change of service providers, an outsourcing type situation. Currently, before such a transfer, the outgoing employer must inform and consult with representatives of affected employees. These can be existing reps, for example, trade union representatives, or ones which are elected especially for the purpose. However, the need to elect representatives can be cumbersome and a bit tedious, where, for example, you've only got a small TUPE transfer, say you're outsourcing your catering function and there's 5 employees who are going to transfer. There's currently a micro employer exception, which allows employers with up to 9 employees to inform and consult with the affected employees directly where there's no existing representatives in place. And under these new rules, that micro employer exemption will be extended to businesses with up to 49 employees or with any number of employees where there is a transfer of up to 9 employees proposed. But it's only going to be available where there are no existing employee representatives. The reform will obviously be welcomed by employers, albeit that consulting with, say, 40 employees may end up being more time consuming and cumbersome than consulting with just representatives. The relevant law introducing the change was passed on the 1st of January, and the new rules will apply to transfers and outsourcings occurring on or after the 1st of July this year. So if you have trade union representatives or a standing employee representative body, the change won't apply to you. If you are, for example, a consolidator or an outsourcing organization, then there will be potential changes to where you run these processes. Going to move on now to talk about sexual harassment and a new duty to prevent sexual harassment. Now, currently, employers are not legally obliged to take steps to prevent sexual harassment at work, save to the extent it falls under the duty to take reasonable care of health and safety. Of course, many employers do this, because it's the right thing to do, but also to reduce the chance of it occurring and claims occurring. Further, where an employer wishes to be in a position to avoid liability in an harassment claim, including sexual harassment, it can show that it has taken all reasonable steps to prevent it from occurring. Now, most employers take steps which would allow them to argue this kind of defence, but they don't have to take those steps. And actually, the bar you need to reach to successfully argue the so-called reasonable steps defence is quite high. For example, in a recent case, an employer's reasonable steps defence failed because its dignity at work policy had not been reviewed for over 3 years and it hadn't delivered comprehensive equality training to staff. And in another case, the defence failed because the training had become stale after 20 months and should have been refreshed in that time. The new position is this. From later this year, you'll have a mandatory duty to take reasonable steps, but not all reasonable steps, to prevent sexual harassment in the workplace. So it's a lower bar, but it's going to be a mandatory obligation. Where an employer breaches this new duty, employment tribunals can uplift compensation by up to 25%, and the Equality and Human Rights Commission can also investigate suspected breaches and take enforcement action, all of which will be in the public domain. The provisions in the new Act will come into force 1 year from the day on which it was passed, so by the 26th of October this year. If you're already working towards being able to rely on the reasonable steps defence, then you should be able to demonstrate compliance with the new duty because it's a lower threshold and only encompasses sexual harassment. All is not lost for employers who find themselves unable to rely on the reasonable steps defence because not every reasonable step was taken, and those employers will still have a shot at demonstrating compliance with the new duty, provided that some preventative steps were taken. And not only would this avoid the potential uplift in compensation, but it may reduce the chances of negative press attention, which we think will come about in cases of breaches of this duty. So we would advise employers to work towards being able to rely on the all reasonable steps defence. I say because it's the right thing to do, it reduces the chance of harassment actually occurring, and it puts you in the best place in any future litigation. This slide summarises what we think you should be doing, including considering updated statutory code and accompanying guidance, which the Equality and Human Rights Commission has said it will publish, have a very robust suite of policies in place, be clear about standards of behaviour expected from staff, including explaining that disciplinary action will follow where those standards aren't met, raising awareness of your policies in the workforce, reviewing them every year and documenting that review, including looking at trends from internal complaints, staff surveys, exit interviews, those sorts of things. Putting in place methods to detect harassment, including formal one-to-ones, return to work meetings, exit interviews, or perhaps even an external reporting system. Providing high quality and regular equality and anti-harassment training to staff, ensuring it's balanced, thoughtful, clearly presented, regularly refreshed, and all of this, including attendance, is tracked. And deal with complaints effectively, including taking swift and appropriate action in disciplinary cases. I'll hand you back to Amanda now for a final roundup of what's on the horizon.
Thanks, Tom. So just a quick look at some other things that are coming down the tracks, but that are not concrete changes of the nature of the ones that we've discussed already today. So first of all, neonatal leave and pay. The Neonatal Care Leave and Pay Act was passed last May, so this change is definitely going to come. And the Act provides the pathway to new rights and protections at work for employees who are parents of babies up to 1 month old who require neonatal care. And they will be given a day one right to take leave where the baby has at least a week in neonatal care. And for those employees with at least 26 weeks service, they will also have a right to be paid statutory neonatal pay. But we are still waiting for regulations which will set out the finer detail of how the rights are going to work. We haven't got those regulations yet. However, the government has said that the neonatal leave and pay rights will be delivered by April 2025. Now, of course, we will have a general election in that intervening period, but I think this change will be delivered even if we see a change of government before then. So that being the case, there's nothing particular for you to do at the moment other than to diarise to see where things stand in about 6 months' time. The second change on the slide concerns the limitation to non-compete covenants. So you probably remember that last May, the government said it was going to legislate to limit the length of non-competes to 3 months. And the proposal was that it would apply to non-competes only, so not to other types of covenants, such as non-solicitation covenants or non-dealing covenants, and that it would only apply to employees and workers engaged under employment and worker contracts, but not to wider types of workplace contracts like shareholders' agreements or long-term incentive plans. Now, the government said it will definitely bring these changes in, but when parliamentary time allows. At the time of preparing for this webinar, we've got no further information on when that will be. So no concrete actions needed just yet. That said, it would be sensible for you to at least audit your existing employment contracts and just ascertain how many of them have got non-compete restrictions in excess of 3 months, so that you know where you stand if this change does come in. The third change I put on the slide, well, what would a Labour government mean for employment law? Well, back in September 2023, the Labour Party published a green paper entitled A New Deal for Working People, setting out its proposals for change in workplace rights. It was a very ambitious document with over 50 proposals for change across a wide range of areas. I've put some of those on the slide. And just yesterday, the party announced plans to introduce a new act which would give Black and minority ethnic employees and disabled employees the right to bring equal pay claims for the first time. And also, they propose to introduce a right to bring discrimination claims on the basis of a combination of 2 different protected characteristics rather than 1, as is currently the case. And it's estimated that this will give rise to 21 new types of combined discrimination claims. So if these various proposals are taken forward, there would be a seismic shift in employment rights and plenty of fodder for new webinars, you'll be pleased to hear. However, as we all know, what politicians say and what they do are 2 very different things. So I really think it's a case of having to wait and see. And last but not least, and a very late entry, so it's not on the slide, just in the last few days, the government opened a consultation on the reintroduction of fees in the Employment Tribunal and Employment Appeal Tribunal. And you may remember that the old fees regime, which ran between 2013 and 2017, had a scheme where the fees were relatively high. And that actually resulted in a very sharp decline in claims, which was ultimately taken to the Supreme Court, who struck down the scheme as unlawful on the basis that it impeded access to justice. However, the question of whether a lower, more proportionate fees regime would have been lawful was left open, which brings us to the present day. The consultation proposes a £55 issue fee payable by claimants in the Employment Tribunal, which would cover the entire journey of the claim in the system. And similarly, a £55 fee payable by appellants in the Employment Appeal Tribunal. And again, that would be for the entire appeal. It wouldn't cover that. There wouldn't be any separate hearing fee. The consultation closes on the 25th of March. And so the government are going to need to get its skates on if it wishes to push this through before the general election. I can't see a Labour government taking this one forward. So that's it from us today. On the slide, you will see our contact details. Please do feel free to get in touch with us in connection with anything that we have discussed today. And we do hope you found today's webinar useful.